Ladies and gentlemen of the jury, this is the point in the trial where we are going to do what we told you we would do when we talked to you individually on that first day you reported for your jury service. This is a point of the trial where we make that big ask. The point where we ask for your recommendation of death in this case. We do not take this ask lightly. We are not flippant. We are not naive. We are not ignorant of the fact that this ask is one that will literally alter the person's life. But before we make that ask of you, that ask of the ultimate punishment, I want to go through the evidence, the aggravators and the mitigators, and to remind you why this case is different from others. Why these murders are aggravated and how they stand out from other cases. And as we talked about on that first day of jury selection, there are only certain cases where the state can even seek death, or as the defense said, special cases. An aggravating factor is the only circumstance under Florida law that could result in a defendant receiving the death penalty. And there must be one aggravating factor for each of the state to seek death. And the notice we filed has 4 aggravators. 4 aggravators for the death of Christine Melton and 4 aggravators for the death of Diane Ruiz. And the state only has to prove one to ask for a recommendation of death for each. I'm not going to go through each aggravator at length because my colleague did that in his opening statement, where he reminded you of the details that came out on the trial. And you can review any of that evidence. You can rely on your notes and what you heard in the trial to make your decision about the aggravating factors. But I want to start briefly and go through the aggravators and how we've proved them. Let's start with a capital felony was a homicide that was committed in cold, calculated, and a premeditated manner without any pretense of moral or legal justification. You already found beyond a reasonable doubt that the murders were premeditated through your verdict. You found 2 counts of first-degree premeditated murder. You must now find that that premeditation was heightened, demonstrated by a substantial period of reflection. In order to do that, I think it's important to start at the beginning of this case, where it all happened, off McGregor Boulevard, near College Parkway, at the Buddha Lounge. Music was playing, people were socializing. The defendant went there to have a good time. And he discarded the woman he came with, and he chose one that caught his eye, Christine Melton. And as he told detectives, this is what I do with women, you know. I use my charm, I use my good looks. That's what I did with the first girl, and that's how I got in her head. And look what happened to her. When the defendant first approaches Christine, he's not threatening. He's smooth, he's charming. He's nice to her and her friend Stephanie. They party together, no red flags, no sign of aggression. He's a fun guy, but he waits. He waits until he's back at her house, in her bed, and Stephanie has gone home. He waits until he is alone with her, until there are no other witnesses. He waits until she is asleep, defenseless. The defendant says she can't get away from him, even if she wanted to, because he's too strong. And when she can't get away is when he kills her, when he strangles her, because he was the lion and she was the prey. But he didn't stop there. He was looking for more prey. He found Diane Ruiz walking in Cape Coral and said, that's the one. You know what? I've already done it once, and I'm going to do it again. He knew there was a school, but he wasn't worried about the school. He wasn't worried that it was daytime, because he got her into his car. He got her alone, and that's when he attacked. He decided he was going to kill her when he saw her walking, and he already knew that he was not going to let her go. He could tell she was getting scared, and he saw her fear. He knew Diane wanted out of that car bad and that she was afraid. He could sense her fear, but what was he? He was a lion, and she was her prey. He had a careful plan. He didn't murder Christine or Diane in front of people. He gained trust. He selected Christine at the Buddha, and he selected Diane as she was walking. He secluded Christine in her own home, and he secluded Diane in the car. And then he tortured and strangled them both. He used calm and cool reflection. He waited to kill Christine. He waited after they had left Jason's home. He waited all night into the early morning hours after Stephanie had gone home. And that's when he killed her, not in the heat of passion, but when she had gone to sleep. He waited for Diane. He waited until he saw the right person. He waited until she was in the car. He waited to reach out and choke her. This wasn't a lover's quarrel. There was no fight. He was calm, and he used cool reflection. The way in which he killed both Christine and Diane was in a cold, calculated, and premeditated manner. The second aggravator is that the capital felony was especially heinous, atrocious, and cruel. The jury instructions define heinous, atrocious, and cruel, and it states that the murder is one which is accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Christine Melton or Diane Ruiz. Strangulation alone is heinous, atrocious, and cruel. Why? Because the victim is aware she is going to die. The victim knows what is about to happen as that perpetrator's hands are wrapped around her neck. And the force that must be used to kill with his hands was significant. Christine Melton was woken out of her sleep. The person she had just partied with, the person she was intimate with, the person that had built her trust, the person she had led into her home, into her bed, had his hands around her neck. But before he killed her, he inflicted torture. He inflicted pain, and he showed utter indifference to her life. We know she suffered before she died because there is evidence she tried to fight him. Her fingernails were broken. Her brain was swollen. And the swelling occurred from blunt force trauma that the defendant inflicted on her before she died. She was covered in bruises. She was bruised on the outside of her body. She was bruised on the inside of her body. She had bruising of numerous internal organs. She had hemorrhaging and bleeding on the outside of her body and hemorrhaging and bleeding on the inside of her body. She had injuries to her head and to her brain. The defendant seemed to enjoy the fact that she suffered, and he told his dad such things. For Diane Ruiz, he pulled her into his car and beat her. He broke her nose. He grabbed her by the neck, choking her, strangling her. He pressed so hard that he broke her hyoid bone and broke her thyroid cartilage. And like Christine, we know too that she fought back. Diane had defensive wounds. She had bruising on her left forearm and the back of her hand. And the defendant said when talking to law enforcement, she was a fighter. I'll give her that. And as he choked and strangled her, applying far greater than 10 to 15 pounds of pressure, she came back to life 3 or 4 times. And as he drove through Cape Coral trying to find a place to deposit her body, she was still alive. And when he pushed her out of that car and she got back up, what did he do? He ran over her. He said he ran over and over her, making her look like spaghetti. She had a laceration under her breast. She had hemorrhaging in the back of the neck, on the spine, and all around the vertebrae of the bones of her spine. And the significance of that hemorrhaging is that there was a significant force that went through that region while she was still alive. And Dr. Coyne is the one that testified to that. Because if she was already dead, there would not have been hemorrhaging in those areas. She knew her attacker was the defendant. She was conscious of her attacker. She was conscious of the beating. And most importantly, she was conscious of her impending death. Not only did she feel pain, ladies and gentlemen, but she was afraid. The defendant testified that he saw her fear, but he wasn't about to let her go. He was going to, and he did inflict a high degree of pain with utter indifference to Diane's suffering. The way in which the defendant killed both of these women was extremely and outrageously wicked and shockingly evil and vile. Both murders were especially heinous, atrocious, and cruel. The third aggravating factor is that the defendant was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. He didn't just kill one woman, he killed two. Two innocent victims, one trying to go out and have a good time, and another just trying to get to work. And the defense conceded in their opening that the state had already proven this aggravator beyond a reasonable doubt. The fourth and final aggravator for each of these victims is that the capital felony was committed by a person previously convicted of a felony and under sentence of imprisonment or placed on community control or a felony probation. You heard from Lisa Lansky, the print examiner, who compared his prints from being sentenced and being placed on probation to the prints that were rolled in court, and they were one and the same. And you also have the certified records and evidence showing that he was on probation at the time of these murders. And the defense in their opening conceded to this aggravator as well. An aggravating factor increases the gravity of a crime or the harm to a victim beyond the harm inherent to every first-degree murder. The state has met our burden, and we've shown you how we have proven the aggravating factors beyond a reasonable doubt. We have proven that this first-degree murder case is an aggravated one. And it's one so aggravated that the legislature has laid out the law that death is an appropriate penalty given the nature and circumstances of these murders. The defendant chose his victims and acted in a way that shocks the conscience of any human who hears the facts and sees the evidence that you saw and heard in this case. The defense presented mitigation during this phase. Anything can be considered mitigating, and you're to consider each of these mitigators. Unlike aggravators, however, where the state's limited by statute, the defense is not limited. However, each of you individually get to decide how much weight, if any, to give to these factors. So I want to go through some of them. And you'll hear, when the judge reads the jury instructions, you'll hear all of the mitigators that they've listed. But I want to go through some of the main ones. Let's start, however, with the expert testimony. You heard from Dr. Mills. He testifies solely for the defense in capital cases. And he said on the stand, I was hired to try to help him. Not to give an objective opinion, not to conduct testing and to try to find out if he suffers from a mental disorder, but yet he was hired to try to help him. And the only people he helps are defendants. He only works for defense. His testing that he was able to accomplish, the MMPI and the PAI, were invalid because of the defendant's exaggeration. And once those tests were invalid, the defendant refused to meet with him again, refused to provide any additional data. And what was interesting about Dr. Mills is that he discounted the records in front of his face, the evidence that he had before him. He did very little review of the records. And in fact, when I asked him, initially he had said he hadn't reviewed those records. And then on the stand, he said he did review the records. But when I asked who these people were, he couldn't remember. But he gave credence to records that don't exist. He said the hundreds of pages of jail records were basically useless. Yet he relied on the mom's report, which was extremely limited, with no supporting documentation. There was only one evidence of a Baker Act in 30 years. And the Baker Act was because his dad found drugs. And he was released from the facility the very next day. And when I asked him, isn't that unusual, doctor, for someone who supposedly has schizophrenia or some major psychotic disorder to be released the next day? He couldn't say yes. He said, well, maybe his parents don't really remember. Don't you think his parents would remember that if their son was in a mental hospital for an extended period of time? So he doesn't give credence to the Baker Act. To that report, he can't really rely on it, but he's going to rely on other vague things that the parents tell him. He tries to build a diagnosis on two things the parents told him. That there was someone in the garage on one occasion, and that people were looking through the windows. That's the basis of this doctor's diagnosis. He also tries to give credence to there being a major mental health issue and try to say that that mental health issue came first. But when do those changes in the defendant occur? When he's 13. And when do his parents notice these major changes? When he's 13. And what did the defendant tell the investigator? That he began heavy drug usage and got into drugs when he was 13. Yet Dr. Mills discounts the defendant's own admissions and the reason for the Baker Act because they don't fit the narrative of a psychotic disorder. They fit the narrative of substance abuse problems. He discounts the school records. He discounts that the defendant was kicked out of school for selling drugs, not for psychotic episodes. And the defendant also admits that he was kicked out of school for selling drugs to his own investigator. And we had a conversation both with him and with the state's expert about the DSM-5 TR. And it clearly states in there that drug use must be ruled out to make a diagnosis. And that you can't diagnose a psychotic disorder under the circumstances in which Dr. Mills did because he could not rule out drug use. Nowhere in the records could he find the criteria laid out to support the diagnosis of a psychotic disorder. He had 13 years of medical and mental health records, and there was no specific instances of hallucinations and no specific instances of delusions, and no diagnosis of schizophrenia. And these are some of the things that were required to make such a diagnosis. And the only drug he was prescribed through all these years up until 2022 was for depression, Celexa. And both doctors came up in their rebuttal after Dr. Herkov testified and listed out for you a bunch of medications that could potentially be used to treat a psychotic disorder. But the problem, they weren't prescribed until 2022. And again, nowhere in the records was he even given a diagnosis of a psychotic disorder, not even in 2022. And I asked the doctors if they had reviewed the emails where the defendant was trying to find out more about drugs and that drug addicts are often med-seeking. They hadn't reviewed those emails. The family's recantation of paranoia and of him believing people are watching him can't be attributed to a mental health disorder because by the defendant's own admission, he's on drugs, which also is a cause of hallucinations and delusions. Here's a doctor who can't gain cooperation or get information from the defendant, yet he chooses to essentially ignore the case documents. He doesn't review the videos. He doesn't review the tangible evidence from the case. Because the problem is, the evidence that you heard and saw in this case do not support a diagnosis of a psychotic disorder. And he has to downplay the jail records because they also don't support the diagnosis of a psychotic disorder. You also heard from Dr. Hyman Eisenstein. Now, his background was very limited. He only worked for a rehabilitation hospital for a year, and then he started doing contract work. And in his contract work, he, in the 80s, got involved in a death penalty case and decided that was what was going to become his specialty. And he said that he's testified in over 150 capital cases. How many for the state? None. All on behalf of the defense. And what is a diagnosis in almost all 150 cases? The same. Imagine that. Prefrontal lobe damage. Now, unlike Dr. Mills, Dr. Eisenstein actually spent a lot of time with the defendant. And during that time, he saw no evidence of psychosis, no evidence of delusions, no evidence of hallucinations. And when the defendant reported about mental health issues, it was all in vague generalities. Dr. Eisenstein didn't ask details. And when I asked him, well, what was he hallucinating? What were delusions? He didn't know. He didn't ask because guess what? He was just there to test his brain, to see if his prefrontal lobe cortex was working, which we already knew was not going to be given his testimony that he gives in all of these cases. He also kept saying during the defense direct examination that, the defendant had all kinds of diagnoses, all these diagnoses. And when I asked him where in the records he found any kind of evidence of schizophrenia, he said, I misspoke. I didn't find evidence of that. And the problem is his testing didn't say what he wanted it to say, what he tried to make it say to you. He said that this guy scored in the 2nd percentile in regards to his memory. That means, as Dr. Herkoff said, only one person in line is behind him. That's how bad. Yet when you look at the case files and the videos and listen to the statements, there is no evidence of memory impairment. In fact, I would submit his memory is actually more than fine. There's also nowhere in the records that suggest his memory is impaired, which would be startling for a 30-year-old to have dementia or some major memory impairment. No signs in the records. And in fact, what do the records say? They say opposite. Dr. Herkoff found in the records where it said his memory was intact. His parents didn't indicate he had problems with memory, and the defendant didn't complain he had problems with memory. And when you see the doctor's own testing results up on the board that Dr. Herkoff showed you, his executive testing and front lobe testing didn't show any damage. Dr. Eisenstein didn't review the case records at all. He knows very little, if anything, about the facts surrounding the murders. And what does he do? Same thing as Dr. Mills. He discounts the records in front of his face and gives credence to records that simply don't exist. He states that the defendant had synergistic brain damage through all of the head trauma. And where does he get this information from? The defendant's father, who indicates he's had some bumps and bruises from playing sports, none of which landed him in the hospital, and none of which required any kind of treatment. And the 2 car accidents, the first one, no treatment, didn't go to the hospital, no follow-up care. And when he went to the hospital in the 2nd car accident, he had a CT scan, it was negative. There were no issues, no bleeding, no problems. The defense attorney, the expert, Dr. Eisenstein, tried to suggest that somehow taking a test is significant, that having a CT scan in and of itself is significant. That's like saying it's significant that if a woman takes 20 pregnancy tests and all are negative, that it means something. Taking a pregnancy test doesn't equal pregnancy, and having a CT scan doesn't equal brain damage. In fact, all of the CT scans were of no significance, and his own sister, who's a radiologist, who's trained to read CT scans for a living, confirmed this information to Dr. Eisenstein. So some falls in 2 sports, and 2 car accidents, one in which he didn't even need treatment, led Dr. Eisenstein to the conclusion that the defendant suffers from synergistic head trauma. Again, he ignored the records in front of him and gave credence to records that don't exist. Now, Dr. Herkoff, the key difference with him is he works for both the state and the defense. He's not here to give an answer that we want him to give. He's here to review the records and to make a decision not based on emotions, but based on the DSM-5 TR. He used the records. He used the data. He reviewed the videos. He reviewed the defendant's statement. And what did he find? No cognitive impairment, no brain injury, and no criteria that meets a psychotic disorder. The majority of the records contain self-reports, the defendant telling staff his diagnosis, the defendant asking for specific medications, and throughout the records, what are the main complaints? Depression and anxiety, treated by Celexa. Two likely problems for someone who is incarcerated. You're going to be given the weighing the evidence instruction, just like you were in the first portion of this trial. And it says expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like all other witnesses, you may believe or disbelieve all or any part of the expert's testimony. And I would suggest that these experts should not be given a lot of credence that the defense presented. You as jurors know more about this case than any doctor who evaluated Wade Wilson does. Neither of the defense experts read through the discovery or read through the witness statements, or very many of them. You are the ones who sat and listened to 28 witnesses. You're the ones that saw the evidence. You're the ones that held the pictures. You're the ones that know what happened in this case. You saw the body cam of the defendant and how he was acting after the murders. You heard his dad testify about how the defendant killed Christine Melton and Diane Ruiz. And you heard the defendant's statement to law enforcement confessing to the murders. It's not credible that mental illness caused the defendant to murder Christine Melton and Diane Ruiz. He was under the influence of power, of lust, of control, of hate. He showed utter disregard for women and for life. The reason for the defense's expert is because most of their mitigation revolves around mental illnesses and drug use. So let's talk about a few of those. The first is that Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorder, delusional, paranoia, social adjustment disorders, hallucination, and preservation. Again, the evidence in this case points to the defendant being addicted to drugs and that his addiction was the source of his problems, not a serious mental illness like schizophrenia or schizoid affective disorder. Certainly he was depressed at times and anxious, but almost everything in his records are self-reported with very little evidence of symptoms that would support such a diagnosis. Another mitigator the defense has listed out is that while Wade Wilson was on drugs, he's out of his mind, on a rampage, makes him crazy, and makes him do wrong things. Contrary to what we see in this case, he was the life of the party that night. He was having a good time, talking to women, making his rounds around the Buddha, listening to music, drinking. He drove to the Buddha that night in an $80,000 car with his girlfriend. He ditched her and meets another girl. He picks her. He's not out of his mind. In fact, he says that 9 times out of 10, this works to get him what he wants. Girls fall for him. He chose Christine, and the only evidence of drug use from that night was a line or two of cocaine. He wasn't on a rampage. He was cold and calculated. Stephanie Johnson didn't see him acting out of the ordinary. She didn't see him out of his mind, on a rampage, acting crazy. Jason Shepard didn't see the defendant out of his mind, on a rampage, acting crazy. Stephanie left at 6 a.m. that morning. No red flags. Everything was fine. Checked in with Christine. You good? Yep, she was good. He did wrong things, all right, but he was and he is fully responsible. He knows what he was doing, and he thought about what he was doing. Another mitigator they list out is the drugs that Wade Wilson took that night before the event led to an unanticipated effect. The mitigator is virtually the same as the one I just went over. But don't let this mitigator be a suggestion of some other drug take away from what you know the facts to be. There's no evidence of him taking any drugs other than the cocaine prior to the murders. In fact, there's no evidence of him taking any drugs after the murders. You see how he parks his car at Mateo Graphics. He backs into the spot perfectly. You see and you heard how he speaks with law enforcement. He engages with them. He denies the battery. And then when he realizes he's going to be detained, what does he do? He takes off. And then you also hear how he speaks to law enforcement 3 days later. He speaks the same way as he does to his father. Another mitigator the defense has listed is that Wade Wilson confessed to law enforcement to do the right thing. Ladies and gentlemen, there was no doing the right thing by this defendant. There was no evidence in that statement that you heard that showed any kind of remorse or desire to just help. There was nothing in his confession that he was doing it out of the goodness of his heart to help the police. He wanted a hamburger and fries. He mentioned that over and over. And he wanted to be in general population instead of isolated by himself. Another mitigator that the defense listed was that Wade Wilson tried to reach out to his biological parents when he became an adult. Why did he do that? He wanted money from his dad. Remember, his dad testified he always wanted something when he contacted him. It was always about the defendant, always what he wanted, what he could gain. That's what this whole case boils down to. It's about him. And why did he reach out to his dad again in this case? To hide him from law enforcement, to get him out of town. Many people, ladies and gentlemen, suffer from drug addiction, but they don't go out and commit murders. Many people suffer from mental illnesses, but they don't go out and commit murders. Many people are adopted, but they don't go out and commit murders. I would suggest that none of these mitigators explained what happened on October 7th of 2019, and that you should give them very little weight. So you are now at the point where you have heard and seen all the evidence of the state's aggravators and the mitigating circumstances presented by the defense. And if you all find that the state proved one aggravator and the defense a mitigator by the greater weight of the evidence, you must weigh whether those aggravating factors outweigh any mitigating circumstances that the defendant proved by a greater weight of the evidence. So what is it exactly that we're asking you to weigh? We're asking you to weigh the curtain rod that was used as part of the torture, that has her blood on one end and Wade Wilson's DNA on the other. We're asking you to weigh how the defendant met Christine Melton, how she looked when he met her, with how he left her. We're asking you to weigh the large number of bruises to her body. We're asking you to weigh her swollen eye. We're asking you to weigh the cuts around her mouth and her eye. We're asking you to weigh the bruising all over her torso, the bruising all over her arms. We're asking you to weigh the blunt force trauma. We're asking you to weigh the significant hemorrhaging on both sides of her neck. We're asking you to weigh the bruising of her lungs, the bruising of her liver, the bruising of the back of her bladder, the bruising to her colon, the significant force to her abdomen. We're asking you to weigh the injuries around her scalp and around her head. We're asking you to weigh the swelling of her brain. We're asking you to weigh his hands around her neck, not being able to breathe, taking that last breath, knowing it would be her last. We're asking you to weigh the cold, calculated, and premeditated way in which he murdered Christine Melton. To weigh how he picked her out from all the ladies at the bar that night, how he flirted and got her to her house, waiting until no one was around, waiting until she was asleep, his hands around her neck, not being able to breathe. We're asking you to weigh the heinous and atrocious and cruel way in which she killed Diane Ruiz. Ruiz, who was simply walking to work. How he met her and how he left her. We're asking you to weigh her fractured nasal bone, the laceration under her left breast. We're asking you to weigh the hemorrhaging and the skin on the left and right sides of her body. We're asking you to weigh the bruising on her left forearm and the back of her left hand, the bruising on her right arm and the fracture of her finger. We're asking you to weigh the hemorrhaging to her neck, her broken hyoid bone, her fractured thyroid, her fractured ribs, fighting her until she was dead. We're asking you to weigh him running her over with a car. We're asking you to weigh the cold, calculated, and premeditated way in which he murdered Diane Ruiz, picking her up while she's walking down the street, sensing fear, not letting her go, getting her into his car, secluding her. We're asking you to weigh the fact that he was on probation when he committed this crime, and to weigh the fact that he killed both of these women within hours of each other. We're asking you to weigh all of these things and any other facts you may have heard in this trial that support each of these aggravators to the very little mitigation in this case. This isn't about numbers, it's about weight. And what weighs more in this first-degree murder case? In these murders, in the murders of Christine Melton and Diane Ruiz, the aggravators are so much heavier, so much more than any mitigation presented by the defense. And so now is the time that we make that big ask. We ask that you make that hard decision, that you recommend the ultimate crime, punishment for the ultimate crime committed by this defendant. Of these two ladies, Christine Melton and Diane Ruiz, on October 7th of 2019. Thank you.